Good morning, Professor. I'm going to get this right. Onwauchi-Willig.
You got it correct. That's
Okay.
exactly right.
We appreciate you coming here this morning, and we're ready for your opening statement.
Great. Thank you very much, Chairman and Justice Wiggins, and members of the Nominating Commission for granting me this opportunity to speak before you today. I also want to thank you for your very important service work to the state of Iowa. I recognize that it takes an enormous investment of your time and energy. I am humbled and honored to have this opportunity to speak with you about my qualifications for appointment to the Iowa Supreme Court. My entire legal career, in fact, my entire life, has prepared me for service on this very distinguished court. In many ways, my life has been filled with opportunity. I am the first generation of American-born citizens in my family, a family that legally came to this country during a civil war, the Biafran War in Nigeria. I was raised by a single mother in predominantly poor and African-American communities in Houston, Texas. Yet I had tremendous opportunities made possible by this great nation's system of government, and opportunities that I took full advantage of at every turn. I am not only highly capable, but also hardworking. I have worked in a job or jobs since I was 14. I attended and graduated from two excellent institutions, one within the state of Iowa, Grinnell College. There I worked in various jobs, including as a waitress in a local establishment. I received my BA in American Studies, Phi Beta Kappa, and as a junior, I served as student body president, the first African American to serve in this position in the college's history. I received my JD from the University of Michigan Law School. There I worked 30 hours per week, in addition to serving as an associate editor and then a note editor on the Michigan Law Review, and working as one of the founding editors of the Michigan Journal of Race and Law. After law school, I clerked for two distinguished judges, one federal district court judge and one federal appellate court judge. As a law clerk, I researched issues related to both civil and criminal cases, attended and worked on trials and oral arguments, and drafted numerous legal opinions. My tenure as a law clerk provided me with significant knowledge about the inner workings of a courthouse. It also provided me with the invaluable experience of drafting judicial opinions, and at the appellate level, of engaging in dialogue and debate with law clerks from other chambers and watching my judge engage in exchange about the law with her colleagues on the court. At this early stage in my legal career, I also became a mother to a wonderful son, the most important job that I've ever undertaken. I also worked as a management-side employment discrimination attorney at two large law firms. My experience as an associate instilled in me an appreciation for teamwork. It also provided me with important insights into the fact and evidence gathering process. While practicing at these firms, I decided to extend my practice as a mother, giving birth now to a daughter. I began a career in legal academia in 2003 when I joined the law faculty at the University of California, Davis. After my family and I decided to return to Iowa, I joined the faculty at the University of Iowa, where I became a tenured full professor of law and a mother for the third time. As a law professor, I've been trained to examine problems in a way that appreciates the complexities of legal doctrine. I also have honed my ability to explain complex issues in a clear, well-written, well-organized fashion, all of which are important for justices in writing opinions and in interfacing with the public. I was able to achieve these accomplishments because of a combination of hard work, drive, a strong will to succeed, support from family and friends, and luck. But those were not the only factors that enabled me to live this life of opportunity. Our system of government, with its checks and balances, played an important role. For example, I, along with many others, benefited greatly from key legal decisions. I was able to take advantage of the opportunities available at the institutions that I attended and to reap the benefits of that education in my career, in part because of the public education that I received in public schools in Houston, Texas. In Houston, a part of the former Jim Crow South, I attended fairly good, racially integrated schools from kindergarten to 12th grade. My presence at these schools was partially the result of changes that occurred in the aftermath of the U.S. Supreme Court's decision in Brown versus Board of Education, which held that laws that segregated schools, public schools, by race were unconstitutional. Prior to that, African American children were relegated by law to racially segregated substandard schools. But it's not just my opportunities in higher education and my career that have been enabled by our system of government. My family, too, has been influenced. My husband, a native Iowan from Martell, is white, and we and our children have been able to live freely across the United States because of Loving versus Virginia, a case in which the U.S. Supreme Court held that laws that prohibited and punished interracial marriage were unconstitutional. As an American, I am proud of the checks and balances in our government. I am a believer in the courts and the important role they play in ensuring justice. As an Iowan, I'm even prouder of the distinguished history of the Iowa Supreme Court. For example, the opportunity-filled lives of my children are made possible in Iowa in part because of the Iowa Supreme Court's decision, Clark versus Board of Directors. There, the Iowa Supreme Court held in 1868, nearly 100 years before Brown versus Board of Education, that a black child in Iowa could not be denied admission to a public school because of race. The court did so by giving effect to the text of the Iowa Constitution, which provided, quote, "The Board of Education shall provide for the education of all the youths of the state through a system of common schools," end quote. The court also looked to the text of related legislation that gave effect to this constitutional provision, legislation which the Iowa legislature had changed over time from stating, quote, "Schools shall be open and free alike to all white persons in the district between the ages of 5 and 21 years," end quote, to this modified language. Quote, "In each subdistrict there shall be taught one or more schools for the instruction of youth between the ages of 5 and 20 years," end quote. There was no more mention of race. The Clark opinion, which is often pointed to as a guiding light in Iowa's judicial history, was written by Justice Chester Cole, a former law professor at the University of Iowa, and one of the founders of both the University of Iowa College of Law and Drake University School of Law. Which brings me to my next points. I am not just well qualified for a seat on the Iowa Supreme Court, I believe that I am the right person for one of the 3 current openings. First, I would greatly enhance the court because of the diversity that I would bring through my work experience. Courts are strengthened by having a group of smart lawyers that are diverse on many levels, engage in discussions about complex legal issues in each case. Having a cross-section of work experience, life experience, and demographic representation on the court is important for ensuring the inclusion of a broad range of questions and considerations during the deliberative process. Because of my work and life experience, I bring many important qualities needed in a Supreme Court justice. I bring strong analytical and writing skills. I also bring significant experience in speaking about legal doctrines to people who are not fully trained in the law, a task that justices must perform regularly through their opinions and in public appearances. I also bring skills that are critical to working with other people in reaching decisions and administering the courts. As a faculty member, I am regularly engaged in meetings that require creating rules and policies for the law school, and in decision-making for national committees and boards, and in managing budgets for national events. I am a good listener. As a practicing attorney and as a mother, I learned the importance of reserving judgment before considering various perspectives, and I've continued to hold this quality dear throughout my career. I consider and analyze all questions before me, and I respect the people with whom I work regardless of viewpoint. All of these qualities are critical for justices who must both challenge and respect each other as they work to reach the right legal decision, and who must respect the lawyers before them during oral arguments and on paper. The time is ripe for adding a law professor to the Iowa Supreme Court. 2 justices on the U.S. Supreme Court are former law professors. Our neighbor to the south, Missouri, the first state to adopt the Missouri Plan, and hence the name, but our process for selecting judges, has a former law professor on its Supreme Court. And our neighbor to the north, Minnesota, where justices are also named by appointment, has a law professor on its Supreme Court, who, by the way, is younger than I am. My appointment to the Iowa Supreme Court will recapture Iowa's very important early history of including academics like Justice Chester Cole on its court. Additionally, as an African-American woman, I bring important racial and gender diversity. Courts should reflect the populations that they serve. Justice Ruth Bader Ginsburg of the U.S. Supreme Court recently talked about the importance of the appearance of inclusion on courts. She referred to the fact that the U.S. Supreme Court now has 3 women on its bench. And she said, quote, "When the school children file in and out of the court and they look up and they see 3 women, then that will seem natural and proper, just how it is," end quote. The appointment of a highly qualified African-American woman to the Iowa Supreme Court, a court that has never had an African-American justice, either male or female, and has only had 2 female justices on its bench, would counteract long-held notions about what looks natural and proper on the Iowa Supreme Court. Most of all, I should be appointed because I'm committed to justice through the law, and I'm well qualified to apply it. The Iowa Supreme Court performs an important role in ensuring the protection of the rights of all of its citizens, and I believe that I have the right experience, the right analytical and writing skills, and the right temperament for a seat on the Iowa Supreme Court. I ask that you include me on the slate presented to the governor. Thank you very much for your time.
Professor, I need to ask this question,
Sure, of course.
and you know what the question is.
I know what the question is.
You're not licensed to practice law in the state of Iowa, and the Iowa Constitution requires you to practice law to be a member of the Iowa Bar. And I know we've talked about you trying to get licensed before this, but I don't know if it's going to happen. And our charge is to send people who meet the qualifications, either by age or by license, to the governor. We have to send 9 people. If we send you without a license, we're really sending 8 people. So tell me, in your best way, how we can get around the Iowa Constitution and do that.
Well, if I were making the argument, the Iowa Constitution, I think, requires that I must be a member of the Iowa Bar before I become appointed. And I am confident that that would happen, that this would come through before I'm appointed. I can tell you there's a 2-step process. It goes to the National Conference of Bar Examiners first, and then it comes here, from which I understand it could get processed very quickly here. The National Conference of Bar Examiners, everything is in except for my criminal history check, and I actually think I was what's missing. I don't have a record. It should come back quickly, and once they have all that information, they can send it, and Dave Ewart can see it the very next day. So I'm confident, I'm fairly confident that it will happen in a timely fashion, and hopeful, very hopeful that it will happen before you begin your deliberations.
And if it does, I'll be glad to swear you in. Any other questions? Mr. Fitzgibbons.
Good morning. Thank you for being here. You do certainly bring some unique characteristics and talents to the pool of qualified people that come to see us. And you're a law professor. I've had a chance to look at your journal articles. You've been published in 2 of the most prestigious law review journals in the country. And you're a professor, which is a bit different than perhaps the vast majority of candidates. I've been concerned, and I think many people are concerned about the lack of women on our Iowa Supreme Court. In fact, some would tell you it's akin to an embarrassment. When you teach young aspiring students, what do you think they take from the fact that they're attempting to craft themselves and mold themselves into lawyers, and they look at our bench and there's been a really lack of representation of women and minority women, obviously. What do your students tell you when they see that?
Right. So I cannot underscore Justice Ginsburg's point enough. I think that there are very, very important symbolic reasons for considering gender as you think about the slate. One, the very reason, just even broadly speaking, I'll speak about my students in a second, but broadly speaking, it's a part branch of our government. It's part of our government, and people need to have faith and trust in the government, and people will have more faith if they feel like their voice is included. And so to see a reflection of oneself on the court is very important for that reason. But my students are definitely thinking about that. My students are constantly asking me about questions about the lack of female partners in law firms, or they're constantly asking me questions about how do I balance family and having a career. So I think that women are taking, the women in my law school class and in my classrooms are taking their cues from seeing representations across particular fields, and I think some of them are making choices, which I think is unfortunate, based upon those cues. So for example, I have women in my class who start off thinking I have to have this particular kind of practice because I plan to become a mother, and they're not considering the broad range, and that's because there aren't women represented in particular fields. Always got to include. The other thing is I think that the reason why it's important to think about gender as you're creating the slate is that when you're thinking about creating a slate for people, for the governor to appoint to the Supreme Court, you're thinking about creating a team. The Supreme Court is made up of 7 people who work together, who debate these issues, who research these issues, who are exchanging opinions, and we want 7 people who are going to complement each other in that process. And I think that it's important to have women there for a variety of reasons. It's important to have women there because the experience of having a woman may have an influence on how someone views a particular fact in the case. So I see this all the time, especially in employment discrimination, that men and women may see particular facts in a case differently. I think it's also important because you want to have a variety of different people on your bench. You want to have a variety of different work experience. You want to have a variety of different people on the bench. And I think you have well-qualified women and well-qualified minorities before you. But you want to have a variety of people on the bench. People are going to make the strongest team possible. We don't have 5 point guards on a basketball team. We don't have 11 quarterbacks. We have people who bring different strengths to those teams. And I think when you're thinking about the slate, I think gender is one of those strengths.
Thank you. Ms. Walker?
Thank you, Professor. I'm not brave enough to try your name, so.
I have to tell you, I made her teach me how to say it when she came and saw me.
Okay, good. There's going to be situations that would be presented to you where it may be against a personal viewpoint, or it may be something where procedurally you have to decide differently than you would have if someone makes a procedural error. Can you describe for us how you would handle that, or I guess how you would process through that and being able to still do the right thing, even if it doesn't specifically go along with what you would like to happen?
Absolutely. I think the most important function for a judge is, to quote Justice Sotomayor, is fidelity to the law. And I think as lawyers, we all have to set our personal views aside. We have to strip down like runners, to quote another person, and apply the law. And I'm fully capable of doing that. There are many situations in my life where I've had to set aside my personal feelings and apply the standard that was before me. And so I can provide.
That's fine, thank you.
Ms. Skogerson?
Ms. Onwauchi-Willig, did I say that
Yes,
right?
absolutely.
Okay, thank you. You're clearly a candidate of very high caliber and very impressive. I think the primary concern that I have is is how you would put your finger on the pulse, if you will, of what's going on in our Iowa court system right now, how you would be able to hit the ground running with our trial courts, our Court of Appeals, and our Supreme Court, and all the administrative duties. How would you connect yourself, I guess, with our Iowa-specific court system?
Right. So I agree that it would take more work for me, perhaps, than many other people to engage in that task. But I feel that I'm up to that task. I'm very hardworking. I have a very deep connection to lawyers in Iowa through the students that I have trained as lawyers in the state. I study courts generally as a law professor, and so I think intellectually and also practically, coming up to speed would not be difficult for me to do. I have every confidence that I could do it. I recognize that it will require hard work, but I'm a hard worker and I'm willing to put in the time to do so.
You have one, Mr. Cook?
I did. How about this, Professor Angela?
I like that.
Not often we get that.
It's kind of Southern, right? So Miss Angela, Miss Benny.
Not often we get the question law professor, so this is sort of a unique situation.
You are a very impressive woman, which I must say exhibits wisdom far beyond your 37 years. Tell me, however, what you've learned from being a mother that you think would enhance this court.
Oh, a number of things. So the most obvious thing is multitasking. That the job of being a mother is very difficult, very time-consuming. But I think the most important thing is to listen to all sides, to consider all perspectives before I know the issue, and to be attentive to the cues about what's missing from any stories that are being presented. I think is also what I've learned from being a mother, and also I've learned in general that the world doesn't revolve around me. That there are other people to be considered, and that there are consequences for for decisions that are made, and consequences for the lives of real people.
Mr. Brody?
Good morning, Professor. Thanks so much for being here. Because of this service, I'm going to be missing the Pioneer basketball game tomorrow night on campus. Disappointed in that. I was intrigued by your narrative on Justice Thomas.
Yes.
Unfortunately, now I have to add that to my list of reading that I have to look at. But I was wondering how that work or any of your other work will guide or influence your work in this room if you get the opportunity to do so.
So, I mean, in general, I think that my work will guide what I do because it's very similar to what I would do as a judge. The research and the writing and the thinking very broadly across all of law to think about what are the potential conflicts that may arise if a particular decision is made. And that's what I generally do when I'm writing my scholarship. With respect to my work in particular on Justice Thomas, I think what it taught me is understanding the complexities of various people's jurisprudence, and in particular, in understanding Justice Thomas's jurisprudence, and to understand also the importance that identity, as I've said earlier, may play in viewing particular cases. So one example would be Justice Thomas, who is someone I think that people who use the term activist court would never call an activist. Right? But he, in a particular case, I was telling someone this the other day, I was reading Virginia versus Black. And it was a case, First Amendment case. There was a statute that allowed for punishment, criminal punishment, for intimidating someone by burning a cross. Unlike a previous statute in a previous case, which was found to be too broad, which said that if you're burning a cross to intimidate someone because of race, religion, and so on, that statute did not have that additional language. But the key point here is Justice Thomas, who is someone that people would not think about as bringing race to the perspective, brought in a very key insight there about the meaning of a cross. And in particular, the question was it conduct versus speech? And he said, it's conduct, it's not speech. It should be regulated. It's not even regulated by the First Amendment, it's conduct. It was conduct that was intended to terrorize a population, and he drew from his experience as a Black man growing up in the Jim Crow South who had witnessed these crosses. Now, it didn't change his colleagues' view, but if you read the hearings from that case, and if you also look at the opinion, it deeply affected their analysis. So one, they found that you could regulate burning a cross generally as long as you didn't have that language because it was one of the signs that's more likely to intimidate people. But they also, Justice O'Connor, in her opinion, included this long explanation about the historical significance of a burning cross. And you could almost see the shift in the hearing after he makes that comment. And you can see the shift in the opinion. You could see the impact of that on the opinion because he brought that different perspective. And that's what it taught me, that people they draw from their experience in very important ways in looking at cases.
Thank you. Do we have any other questions? Ms. Redenbach?
Yes, I'll try to. Professor, thank you for your application. It's exciting to have it in the pool. I've tried to shorten this question, but I'm not sure how successful I'll be. I'm back to the diversity issue of women in the court. And from my experience, and I heard you talk about your entire legal career and entire life, and at age 37, I think, I'm drawing, at my age of 60, I think, well, maybe my entire career or life, but I'm thinking about my experience as a professor of accounting and watching the difference where it used to be all men and now it's majority of women, and still there aren't very many partners in the big accounting firms that are women. We kind of share that in our profession as well. The public accounting profession, they've really tried to address that by having focus groups and that kind of things in those firms to find out what the barriers are. Right. And that's what I see here. We only have 10 women in our pile. And so it's very hard because right away there are a few of those that I just don't think have the credentials to compete, and I can't put them ahead of somebody that has really strong credentials. And so I'm not going to have a mass of women in my group of 9. But I'm wondering if you know if your profession is addressing the barriers of getting women into partnerships or as partners and getting them into district judge positions. What are the barriers? And then how do we help them with those barriers? And if the Supreme Court administration might be one of those places where they could address that.
Mhm. Oh, interesting. Okay, so I think that in my area, my profession, that there are lots of efforts to try to improve the experience of women in the profession, right? So there are lots of, even at the law school level, we're trying to encourage more women to apply for clerkships. We're trying to encourage more women to seek things that their male colleagues are seeking out. And you know, for example, I try to hire, if I can, I try to hire a female research assistant or try to hire someone that I can mentor as well. So I think a lot of people are working very hard to do that, but there are also lots of commissions that are working hard to do that at the partnership level. I mean, in law firms, I think that there are groups that are certainly working to get more women on the bench. I know that. And so there are lots of efforts to do that. I think one of the difficulties is a couple of things. And I think is the balance between work and family life. And so there's a particular age at where you see women leaving the legal profession in droves. And part of it is that our profession still operates on a notion that only looks at sort of the very short-term effects of working as a lawyer. So at the time where women would have to be the most involved in their careers in the law is also a time where they're at childbearing. And you see a lot of women making that very difficult decision. I think it'd have to be a huge cultural shift. I think part of I guess I haven't thought much about what the Supreme Court could do in general, but I think having women on the court is an important step. I think women have to feel like they can achieve that balance. I think it's important also to have women who are mothers on the bench. So one of the comments is you have Justice Sotomayor and Justice Kagan both on the U.S. Supreme Court, neither of whom have children. And so does it take for women to reach that status? Does it take for her to not have children and not to engage in those kinds of balances in her career? I think the symbolic thing is important, but I think also having women who are mothers as well.
Well, I think we're out of time, but I really thank you for putting your name in, and I hope you can get sworn in before Thursday at noon.
So do I. Thank you.
Thank you very much.
Thank you.